Welcome to Heritage University Presents. My name is Melissa Rogers, and I'm the Vice President of Business Development for Heritage Property Management Services. And we are so thrilled that you are joining us this evening for our great class surrounding fining and foreclosure authority. Y'all, this is a hot national topic, and we couldn't be more pleased that partner Frank Olson of Cobb, Olson, and Anderley is joining us this evening to talk about all things related to the fining and foreclosure process here in the state of Georgia. And as usual, if you are returning to a Heritage University course, then you'll know that these housekeeping rules are the same standard as always. But if this is your first time joining us, we thank you so much for giving us your time and attention. This is going to be a 60-minute course where we are just going to go ahead and have Frank kind of explain a few things, but also keep the Q&A for closer towards the end of the class. So what we hope to gain from tonight is Frank have the opportunity to go ahead and talk to you about all of these things that we're going to discuss. We ask that as he's going through his presentation, in the upper right-hand corner, you'll have the Q&A button that you can go ahead and drop any questions that you have as he kind of goes throughout the presentation. Keep in mind, he may actually answer your questions as he goes along through the course. However, at the end of his presentation, we're going to carve out a little bit of time where we're able to do the Q&A portion and get some of your questions answered. As a gentle reminder, this is going to be a very high-level topic of the conversation. While this is a very heavy subject, and I know a lot of you are coming here to get really, really good insight for your community, we do ask that you keep community-specific related questions to a very minimum and address those offline with your association's counsel. Because again, as I said, Frank's going to be talking high level about a lot of things. And most of the things that we're going to talk about tonight are going to be incredibly document and community specific. So without further ado, I introduce you to Mr. Frank Olson.
Very good, Melissa, and thank you so much for that kind introduction. Again, my name is Frank Olson. I'm a partner at Cobb, Olson, Anderley. Our firm specializes in HOA law and practice, pretty much all we do. And I want to give a special thank you again to the Heritage team, Melissa, Josh, and Kate, for allowing me to present to you tonight. I want to thank each and every one of the attendees for wanting to spend an hour with me talking about some things that are, of course, quite relevant in this HOA world. So I'll begin. I'll be talking both about fining and foreclosure authority in Georgia. I'll probably spend the bulk of my time tonight speaking about fining. There's a lot going on with fining, and of course, it's a very hot topic here in the state. I'll finish up with some general remarks about foreclosure and walk you through some of the basic steps of that process, and then kind of tie it all in together, hopefully for you. This is a bit like taking 10 pounds of stuff and trying to put it into a 5-pound bag. So there's a lot to cover, but I hope it'll be informative for you. And with that, let's go ahead and get started. So what I'm going to do at first is kind of walk you through some examples of covenantal language, because that's always the first place that we need to start, right? When we're speaking about fines and whether or not an HOA has the ability to do that. I've given you this example, which is the worst example, and it will get better, but you'll see this first example is taken from some covenants of an HOA that I represent. And this covenantal language, of course, as you can see, actually has no fining power in it whatsoever. What this association is left with, given this language, unfortunately, is simply to file a lawsuit or undertake some self-help against a covenantal violator, if you will. When I first got into this business, if you had told me, Frank, some HOAs can't even fine, I simply wouldn't have believed you. I would have said, well, of course HOAs can fine, right? That's why everybody's mad at them. But it's actually not true, obviously. And so we have some examples of language where an HOA Can't find, this is admittedly rare language, I will say. You will not find this in many covenants, but it does exist. So let me give you a better example. And I call this level 2. This is probably the most common language that you will see in covenants. And this language does mention an ability of this HOA to impose reasonable monetary fines. We'll talk about what that means in a minute. So we've still got some work to do with this HOA because there's no fining amount actually stated in this language. But at least we're in the door now, right? We have an ability to fine, and we simply need probably to flesh out some of the procedures and the process for how we're going to do that. Here's another example that I'll give you of some language. And I, kind of in a funny way, I guess I'm calling this the Frankenstein fine language, but this is an example of covenants where the word fine actually is not mentioned here. And I've actually gotten into some interesting discussions with homeowners and even with board members on occasion about exactly what this means. I'll tell you what I think it means. I think it does mean that the association can fine, because you'll see down at the bottom some of what I've highlighted. It lists a monetary amount, and it's designed to allow the HOA to assess a monetary amount for anyone who fails to comply with the covenant. So I have kind of a love-hate relationship a little bit with this type of language. I'll be honest with you. On the one hand, I like it a lot because it gives you a monetary amount. So it's a little bit better than the level 2, which did not. However, on the flip side, this is very hard to change. And this ties you, unfortunately, as an HOA into a specific monetary amount that you can't deviate from, absent an amendment to this language that would release you from it being, as you can see, tied into the annual, a percentage of the annual assessment amount. But this is better, and this language probably would obviate an association from having to do a fining resolution to further detail the amount of fines that are going to be imposed. Let me give you a final example, and we'll call that level 4. This is the best language that I've really come across in covenants. And the reason for that, why I say that, is because it gives you not only the ability to impose a reasonable fine for any violation of the declaration, but also in that second paragraph, what you'll see is that it sets an initial fining amount at $25 per day per violation. But it also gives the association some flex. So if the association wants, for example, to deviate from that, the association has the power under this language to promulgate a fining schedule that may detail certain fines for certain violations. I have some communities, of course, many of you probably want to maybe make a graduated schedule of fines or assign different fining amounts for different violations. And that's all well and good. This language would allow you to do that. So those are the 4 types of language that we see most commonly in covenants. A question that I get quite a bit as well is, well, Frank, doesn't the law already give us the fining power? Why do we need it to be in the covenants? And I've given you 3 examples of the law that governs HOAs in Georgia. And so the answer to that question is, in a word, no, simply because the law may affirm your right to collect a fine or impose a fine, doesn't mean that's the end of the inquiry. You also need to have that power in your governing documents. So what you'll see here in each of these examples, whether it's the Property Owners Association Act or the Condominium Act, or the third one, which I typically refer to as the common law HOA statute, what these 3 examples all tell you is that the law is actually dependent upon what's in your covenants. So that if you do not have the right in your covenants to collect a fine, the law standing alone will not help you, especially if you're in level 1, as I mentioned before. Okay. So I'm going to park here for a minute and talk to you about the Abdullah case that came down a few years ago from the Georgia Court of Appeals. It's important for us to kind of understand what happened here and understand how that kind of changed the landscape of fines and the ability of an HOA to collect fines in Georgia. So this was a 2019 case. Homeowner in Georgia, Mr. Abdullah, he wanted to plant a flower bed in his front yard, and the HOA said, no, only grass. We're only going to allow grass. He did it anyway. So he didn't get permission from the HOA. The HOA said, okay, well, we're going to begin fining you. And they based their fine at $100 a week. And they based that fining amount on what they had done for the past 10 years with other homeowners. This policy, unfortunately, was not really explicitly stated anywhere. It was just the mode of business or the prior practice of this HOA and how they had done things for a number of years. The declaration, as you can see, I cited a little bit of that language. It falls within level 1, or level 2, I should say. So it allows you to collect reasonable fines, but it doesn't spell out the process. And so the trial court, what happened here was, and actually, just so you know a little bit more of the backstory, it was actually Mr. Abdullah who sued the association. It was not the association who initially sued him to collect on the fines. He sued the association asking for a declaratory judgment or a court order, basically, for lack of a better word, that declared the fines invalid. The association did what's called a counterclaim. And so they sued him back saying, no, these fines are valid and we want to collect them from you. Trial court agreed with the association and awarded all the fines. And on appeal, the Court of Appeals reversed that decision. And they did so on the basis that the fining process was never explicitly stated anywhere in the governing documents of the association. So a couple of big takeaways for you from this case. First of all, and I'm frankly impressed by this, okay, Mr. Abdullah was not represented by an attorney. He did this on his own. I always get a little bit of knocky knees, honestly, when I go up to the Court of Appeals, because there are so many procedural rules and pitfalls in that process. The fact that he was able to, on his own, without the benefit of counsel, navigate that process successfully and beat some frankly seasoned lawyers in our HOA space is itself impressive. But it also, more than being impressive, I think shows you the changing climate that we have in our court system. And I'll talk more about that in a minute, but one of the things that we're really finding is that courts are becoming a lot less hospitable to HOAs, especially when there is a fine balance that we're seeking to collect. So some other takeaways from the Abdullah decision. We can't assume anymore, as HOAs and those who represent them, that the HOA is going to have authority to fine based on generalized language in their covenants. They need more than what was stated here. HOAs also can't rely on a long-standing practice of imposition of fines as being sufficient notice to a homeowner. And lastly, the HOA cannot simply create fining amounts on some kind of informal or ad hoc basis. They need a detailed procedure. That's what was lacking here. And that's really honestly why this HOA didn't prevail at the Court of Appeals. So after Abdullah, I've kind of come up with some best practices, some things to keep in mind, takeaways from this case. First of all, again, don't assume that you're going to win in court. The landscape is changing here for HOAs as they enter the courtroom. Number two, I think what really would have benefited the association in the Abdullah case is if the board had first enacted a fining resolution or a rule and regulation, which nearly all boards are entitled to do under their declaration or their bylaws. They have the power to do that. And to state a fining schedule in that document and publish it to the community. I think the result might have been a lot different had that happened. One other takeaway and best practice I would like to just tell you about real briefly is if you don't already have a hearing procedure or an appeal procedure in your governing documents to tell homeowners how they can challenge or contest a fine that's being imposed against them, and actually give them an opportunity to meet with your board of directors before that fining is imposed, then I would recommend that if you do a rule and regulation or a fining schedule, that you put that procedure in there. One of the things that I think courts are really looking for these days is fairness in the process. They're looking for your HOA to be fair and reasonable in its imposition of fines. And lastly, like I said, publish this rule and reg or fining resolution to your community first. Don't impose the fine and then try to retroactively publish some fining schedule. I don't think that's going to work. I think you need to don't put that cart before the horse. Publish it first, then impose your fine, even if that means you lose out on possibly imposing some fines along the way. I'd rather see that than a result like this in Abdullah, where none of the fines were awarded on appeal. Okay, so I'll talk for another minute or two about another case that came down in 2021, and that's called the Deer Lake versus Brown case. You may have, if you've spoken to me or to other attorneys in the space, we often call this the broken mailbox case. This was a case really, honestly, that sent some shockwaves through our industry, at least as lawyers, and what an HOA can actually do to impose fines and to impose penalties against a homeowner. So here's what happened in Deer Lake. The association sued Mr. Brown for both what they call injunctive relief, or just that basically means a court order ordering him to fix his mailbox. And they also sued him for the fines that they had begun to impose upon him. And I shouldn't say begun because it lasted for 5 years. They imposed 5 years worth of $25 a day fines on him. It totaled $80,225 by the time they initiated that lawsuit. And so what happened is the trial court denied the association's injunctive relief, and they instructed the HOA that it could have done self-help, and therefore they had what was called an adequate remedy at law. So not to get too deep in the weeds here, but when you have extraordinary relief, like you want to ask a court to order somebody to do something, right? That's called injunctive or equitable relief. And it's a high burden to show that threshold and get that relief. And you basically have to show a court that nothing else is going to work, right? I don't have any other remedies except, judge, to get you to order this person to do this. Well, the trial court disagreed with that and said, you do have an adequate remedy. You can go on their property and clean up their mailbox and paint it, right? So they denied the injunctive relief on that basis. Of course, the association appealed this case, and on appeal, the association lost. And the Court of Appeals at least affirmed the trial court's decision not to grant that injunctive relief to the HOA. And so that presented a huge problem for HOAs, because what that meant was now there's a public decision that's been published that essentially requires an HOA to pursue self-help remedies and go on someone's property to fix violations before they can pursue other remedies. You can imagine the confrontations that might ensue from angry homeowners, like the froggy here, who are not going to take too kindly to HOAs and their agents coming upon their property. You could also imagine the difficulty we might have in trying to find vendors who would actually do that and who would actually go on someone's property and start fixing things without really hearing from the homeowner or getting the consent of the homeowner. So it presented a real dilemma to HOAs in Georgia. this Deer Lake decision did. And so, of course, the people in our industry wisely went to the legislature in Georgia and said, we've got to fix this. This is going to be a disaster for HOAs if this decision is essentially allowed to stand. And fortunately, our legislature, I'll talk more about the legislature in a few minutes and kind of what's happening on a more global scale, but here at least, they answered the HOA's call. And they enacted in 2024 a bill called HB or House Bill 220. And this amended the POA and the Condo Act and the Common Law Act, all to strengthen the HOA's ability to seek an injunction or get other relief before or even without first doing a self-help remedy. Now, there were some compromises that had to be had in connection with getting this bill passed. And one of the compromises that we had to live with was that an HOA can only suspend a member's voting rights for failure to pay assessments and not fines. So if there is a fine balance on a homeowner's ledger and you are seeking to suspend that member's right to vote based on that fine balance, you can't do that anymore. They have to be delinquent on their assessments. Okay. So that's Deer Lake in, I guess, a nutshell, if you will. It was quite a significant decision, and the aftermath was already also very significant. I'm very glad that the legislature in this case did what it should have done and what it was asked to do, which is help HOAs out of this dilemma. Okay, so I mentioned before we're going to talk about reasonable fines. I get asked this question all the time. Frank, what is a reasonable fine? Where should we set it? What's the amount? And my answer to that really is I want you to focus more on the process than the actual amount. Okay. The courts, at least as I read the several decisions that have come down over the years about fining and about a fining power and passing upon that, have really looked more at the process that the HOA engages. So the Spratt case, which I mentioned here, that kind of really started the discussion, if you will, about fines. And I think it's kind of where a lot of our industry kind of lands in terms of the amount of the fine, the daily fine that's going to be imposed. That case mentioned that $25 a day, coupled with a bona fide process for imposing that fine and giving the homeowner an ability to challenge or appeal that, giving them essentially due process, was a fair and a reasonable process. So again, that's really where kind of our industry, I think, kind of draws from. You'll probably hear a lot about recommendations from me or other lawyers about $25 a day seems to be a reasonable fine. And we generally look to the Spratt case for that particular opinion. We talked about Abdullah already. One of the questions that I always think about when I think about Abdullah is they really said that the process was bad, right? $100 a week is actually less than $25 a day. But I think it was the process really that the court had the most issue with, not the monetary amount. So if the process had been good, maybe we would have had a case that said that $100 a week is okay. We talked about Deer Lake as well, a case that came down a couple of years after Abdullah. And we talked about how that case, at least at the trial court and at the appellate level, ruled that the HOA should have employed self-help first before imposing an $80,000 fine for a mailbox, and how that was later fixed by statute. And then just 2 years ago, a Salter versus St. Charles HOA case came down, again, passing upon the process that the HOA used and finding that $75 a month in a fine imposed, coupled with a good process, was fair and reasonable. So again, focus more on the process, make sure your process is sound, and then we can talk about the amount. And again, I'm probably going to tell you that $25 a day is the amount that I'd kind of like to see you land on. But that's where those things kind of land. Okay. All right. So here's another topic that comes up in my practice a lot in my discussions with boards is, can we enact a graduated, if you will, finding schedule? And specifically what people on boards want to do is they want to make certain offenses more severe, if you will, and carry a higher monetary penalty than others. So for example, you can see I've given you on the left side an example of a rule and regulation that I drafted recently for a community, where what they wanted to do was they wanted to give an architectural violation a little bit more heft, right? And I certainly understand that sentiment. And I agree with it. I think that somebody building a, pool in their backyard without any kind of HOA approval is going to be a lot worse than somebody leaving their trash can out overnight when they shouldn't. So I certainly understand, like I said, the sentiment of wanting to do a little bit more severe fines for certain offenses. I just want to let you know that right now, that particular procedure does not seem to have been passed upon by Georgia courts. So we are operating in a little bit of a gray area. And I warn my clients this when we draft a finding schedule and procedure of this nature, is to say, we don't know yet how Georgia courts might respond to this. Would they say that that initial fine of $250 is unreasonable? We don't know. But right now, kind of where I land on it is, until somebody tells me explicitly no, that we can't do that, I don't mind as much pushing a little bit of the envelope on your behalf and doing that for you. So let's talk for just a moment about some homeowners' typical defenses to fines that we see. Usually what homeowners are going to claim when you try to fine them is a selective enforcement claim. That's probably the biggest argument that I see. Everyone else is doing it, or you didn't find these 4 homes over here on the next street over, but you're finding me. You're being selective, you're being arbitrary, you're being capricious. In so doing, you're not enforcing things uniformly. And that's actually an argument that can carry some weight. So be aware, if your process is such that you are not enforcing your documents uniformly, you may get challenged on the fines in that regard. Another argument that people make is that you took too long. You waited due to the passage of time, or you've abandoned your claim, or there's a statute of limitations that may come into play. You may know that under Georgia law, an HOA only has 2 years to enforce a covenant violation. That doesn't apply to assessments or other fees, but it does apply to covenant violations. So one of the questions that I get is, well, this person's been doing this for 3 years, or this, shed or whatever has been up for 3 years. Can we still fine them? And my answer would be probably not. At a minimum, you're going to have a court look sideways at you if you try to do that. So it's very important to be prompt if you're going to employ a fining remedy. And then next, sometimes homeowners will claim, well, you told me we could. Don't you remember, Jimmy, when we were down at the pool, on Saturday afternoon, and you told me you were fine with that, shed in the back being put up? Well, if they had some kind of conversation with a board member, and board member told them it was okay to do, and they detrimentally relied on that and built the shed when they really shouldn't have, that's probably a weaker argument than the other two, because usually for an agreement like that, you need it in writing, certainly under an architectural provision, as well as what they call the statute of frauds in Georgia. You're going to need an agreement in writing. So that one's not too hard to defeat, but it does come up. And I would be remiss if I didn't tell you about when homeowners decide to go on the offense. I want to mention this briefly. You may have seen a HUD complaint filed against your HOA, or know of one that's been filed against other HOAs. These can be filed anytime a homeowner believes that enforcement action is being taken against them based upon a protected classification, like their race or their gender. And if they claim that, for example, I'm a minority and you're fining me and you're not fining the Caucasian man down the street for the same violation, that can well serve as a basis for a HUD complaint. Note two things about this. They're free to file. You can do it online. You don't need a lawyer to do it. And here's the kicker. Here's something that shocked me when I learned it. It may not be covered by your HOA insurance. So we typically treat it as a lawsuit, right? And we send it over to the insurance company to put up a defense for the HOA. And in one case I had, a HUD complaint was not covered by insurance, and the HOA had to self-defend, and it cost them $9,000 in legal fees to do that. Another way that homeowners go on the offense, as you saw from the Abdullah case, is Mr. Abdullah sued his association affirmatively. They can do that and often do. Or they can counterclaim. If you're suing for fines, they can counterclaim and challenge the enforcement of your fines. Another big threat that I see is when homeowners decide to go to the media and tell their tale of woe. That's never fun to deal with. I'll talk about my general advice here is don't ever speak to the media. I don't do it. I don't recommend any boards do it. The media is not your friend. I've had even homeowners call the media and try to get them to send a news crew down to annual meetings and film them. It's crazy, frankly. I was quite shocked to learn that homeowners were capable of doing that, and that the news crews would actually try something like that. In one case, we had to kick them out of the room. Facebook's also a big thing. A lot of people get on Facebook and like to complain. Honestly, guys, I'm at the point where I recommend, honestly, that HOAs don't even have a Facebook page. And just don't even do it. Use some other vehicle or method, especially one where you can moderate the comments more. Because if you just are on Facebook and anybody can say anything, it quickly devolves into a nasty scrum. Let me give you very briefly a war story here. So I had one case where, speaking of a shed, someone was building a pool out in their backyard, and the pool was approved and the shed wasn't. The HOA noticed that like maybe a year and a half after the shed went up and said, "You've got to take that shed down. We didn't approve it." Well, the homeowners lawyered up and they took a picture of their shed and sent it over to their lawyer, who sent it to me. And it had a date on there that was more than 2 years from the date that we were trying to enforce, right? As I mentioned, the statute of limitations. And they said, "See, it's been up for more than 2 years. You can't do anything against us." And I wrote back to my board and I said, well, what do you say? Sounds like it's been up for a while. I don't think we can really do anything here. And they said, "Oh, no, Frank, you better watch out. They're backdating their photos." And that's exactly what they did. These homeowners had backdated their photo to make it appear as if the shed had been up for longer than it had been. And part of the reason we proved that was because the board, when the pool construction was initially going on, they had actually toured the property with the homeowner's consent and took pictures of it all. And that was less than 2 years ago, right? So I think the homeowners had kind of forgotten about that visit. But this kind of just describes for you, I guess, a little bit why I'm telling you the story is the lengths that homeowners will go to on the offense to try to combat your fines. Okay, so to speak very briefly about the courtroom and legislative climate on fines, my boots on the ground view here is that it's bad out there, folks. In a word, judges hate fines. They hate their imposition. They don't want to impose them. I get questioned all the time about ledgers, and I get questioned about having pictures. I get questioned about having letters and when did you send that, Mr. Olson? When did they receive it, et cetera, et cetera. And they're looking for ways to disallow fines. So, and I find that with increasing frequency in the cases where we go to court. Legislatively, all I can say is this past legislative session was probably the scariest, and I mean that honestly, in terms of HOAs and the willingness of our legislators to introduce bills that would severely curtail your rights and your ability to collect fines and foreclose, as I'll mention. I'll kind of tie this up at the end, but I just want to give you a flavor for what's happening. There is a groundswell of anti-HOA sentiment out there, both from homeowners as well as the legislators that are listening to them. There were at least 6 or 7 bills that were introduced. Fortunately, they didn't make it past committee, but there were a lot that were introduced this past session, and they will be back, as Arnold says, right? So we need to be on the lookout for those, and we need to be talking to our legislators too and telling them our side of the story, because right now they're only hearing the homeowner side of things. So some takeaways and best practices about finding. Sorry, I'm a child of the 80s. I had to put He-Man in here. If you have finding power of any kind, like I said, I'm going to recommend that you enact a finding resolution as quickly as you can. I want you to include a hearing and appeal right in that finding resolution. If you don't have it, is it possible to do an amendment? I know that's a nearly impossible task to ask of your homeowners to amend their documents to give a board even more power. It sounds crazy even saying it, right? But maybe there's a groundswell in your community of homeowners who are just sick and tired of people not maintaining their lots, their units, whatever. And they want the board to have more enforcement powers. And it's driving everybody's property values down, right? If the houses are dilapidated or not kept up. So maybe you have that sentiment in your community, and maybe an amendment might work. Probably not, but try it. The other thing to consider, this goes back to my comments about reasonableness, is that you might want to consider finding caps. One of the things that I see very frequently is that an association will set a fine in motion for a violation, and the meter, like a taxi meter, will just keep running and running and running. And before you know it, you're in that Deer Lake situation where you've racked up tens of thousands of dollars in fines. One particular way that I see this happen is in leasing. If you have an ability to regulate leasing and pass resolutions requiring, for example, an owner to tell you who lives there by affidavit, if they don't return that affidavit, it can incur a fine. Well, the problem is they don't return that affidavit, and the fine, again, like a taxi meter, keeps going and going and going. And before you know it, there's thousands of dollars in fines because they didn't return a single piece of paper to you. I can tell you right now that there's not a judge in Georgia, I think, that's going to uphold that. Okay. So consider a finding cap on things like that to make it, again, look more reasonable. Maybe a 15-day or 30-day fine maximum on a violation like that might be more reasonable. I couldn't guarantee it, but I would much rather see that than $8,000, $9,000, $10,000 or more in a fine being imposed that we just get disallowed at trial. Consider also some non-monetary penalties. Can you enforce a parking restriction? Can you enforce, suspend voting rights? Can you suspend amenity use? And lastly, can you adopt a POA? Many communities have a POA inclusion clause in there that allows a board without a member vote to actually opt into the POA. And what I like to do for those communities, if they don't have a robust finding power, to add it in when we do the POA so that I can help you and give you that power. Okay, finally, some more takeaways and best practices. As I mentioned before, be uniform in your enforcement. Pay attention to those deadlines. You may be up against a 2-year statute of limitations, at least to sue for an injunctive relief. And that may preclude you from imposing fines from something that's older than that too. I would set a regular and scheduled inspection of your homes. And of course, I would document everything in triplicate. I need time-stamped photos when I go into court. I need delivery of letter proof. I don't need just the proof that we sent it. I need to see the proof that the homeowner received it, okay, if I'm going to get those fines awarded in court. This is the last thing I'll leave you with on fines. I want you to just kind of take this in, okay? This is a ledger from a client I represented a couple of years ago in court. They sent me into court with this ledger. as you can see, there's fines for unkempt condition. I think this was like a unmowed yard, something like that. Well, we start off at $25 a day. That's fine. That's okay. 2 days later, now we're up to a $50 fine. Then we've got two $2,700 fines, including one for putting a window AC unit there. Keep in mind, this HOA did not have a fining schedule or other way to explain these credibly. Then we go up to $75 a day in fines, and that happens for 4 days. And then the next day, we jump up to $150 in a fine. Again, unsightly or unkempt conditions. Then we go back down to $75. As the caption says, the judge looked at me like this, put his glasses down on his nose, and said, "You got to make this make sense to me, Mr. Olson." And as you can imagine, I really couldn't. This ledger doesn't make a whole lot of sense, and we were not awarded fines in that particular instance. Okay. All right. I have just a few more minutes. I want to talk about foreclosures, shift gears a little bit here, and talk about this. So in the world of foreclosures in Georgia, you really need two things, right? First of all, your covenants have to allow you to do this. You have to have the power stated somewhere, much like your finding power, okay? And then if you're a condominium or you're subject to the POA, those statutes impose a minimum balance on anyone's account before you can initiate a foreclosure action against them. So those are the two basic things that you need. A common law HOA does not have that minimum balance requirement. Here's the language that you're kind of going to be looking for in your covenant. Most covenants do have this, not all, because there's, I don't know, tens of thousands of HOAs in Georgia, and it seems like every single covenant that I come across is a little bit different and drafted by somebody else, and maybe drafted by somebody who, doesn't do this for a living like I do, that sort of thing. So they're all a little bit different. So you still need to make sure that you've got the language, but most do. Most allow you to bring suit and to foreclose the lien created by the assessments. Okay. So assuming you have that language, then we're going to take 3 steps, basic steps to undertake and complete a foreclosure sale. First, and this is really more into the condo and POA, but I do it for non-condo, non-POAs as well, is I send a notice of intent to foreclose letter to that homeowner. And under those 2 other statutes, I have to give them 30 days to cure the default before I can initiate a foreclosure action. And that's step 2 you see here in the middle. I file and serve my lawsuit, and then I get a money judgment and an order of foreclosure. And then lastly, the sheriff will take that judgment and take over the process from that point. And what the sheriff will do is actually start advertising the property for sale and then auction the property off at the courthouse steps. So some reasons why your HOA may want to consider a foreclosure remedy, if you have it, is probably the biggest one is if someone is essentially uncollectible. You've tried other ways to get them to pay and they won't. I have this happen quite a bit where, people sometimes are just judgment proof. And the only way to really try to incent them to make good with the HOA is to force the issue and possibly force a sale of their house. Another reason might be your other enforcement methods are not working. You've got a dilapidated property and you can't get this homeowner to comply with anything. This may be a solution for you. We found this solution in particular, I would say, helpful when we've got properties, and I'm sure you're aware of this phenomenon if you're not already experiencing it, is the phenomenon of these Wall Street-backed corporations that are buying up properties en masse in an HOA community and turning them into rental properties and turning your entire community from an owner-occupied community to a renter community. And what we're left with in a lot of cases that I find is that neither that corporation nor the tenants who live there at least care as much as we do on the owner and board side about those covenants and about complying with them. So some reasons you might want to consider an alternative to foreclosure. Number one, maybe this homeowner has some assets that we can garnish. Maybe you see them driving around in a nice new sports car. You know they have a job. You know that there's possibly going to be some pot of gold, if you will, at the end of the rainbow. And maybe we don't want to take somebody's house, and maybe we want to try the other collection methods first. If you're not a POA and you're not a condo, do know that you have to pay off all the existing liens and mortgages first on that property. The reason why the condo and POA communities are utilizing the foreclosure remedy more than a non-condo, non-POA is because they have an exemption in the statute that they don't have to pay off the mortgages first. They can conduct a sale and convey title to a purchaser. Those liens will remain on the property, but you can conduct a sale and convey marketable title to a purchaser. The other reason to possibly consider an alternative is if the mortgage company that holds a mortgage on their property, if there is one, if that mortgage is in default and that mortgage company is seeking a foreclosure, because that's going to wipe out the lien of the HOA regardless. So, and because it's a private sale and not conducted by the sheriff, but it's conducted by that security deed on that property, they have an ability to do it in a much faster time frame than we do. Speaking of time frames, I just want to mention this to you briefly. The maze of litigation. I get a question a lot from clients about, well, how long does this take? For a couple months, right? And then we can foreclose. Oh, no, it does not take a couple of months to do this. The wheels of justice turn slowly. And in many cases, we are subject to the court's calendars and the sheriff's calendars. And so even in a best case scenario, if someone defaults, I've still got several months of lag time between the time that I file that case and then I get them served and then I get a judgment and then I have to put that in the hands of the sheriff to do the sheriff's thing, which is they start noticing up the property for sale. They pick the foreclosure date. I don't have any control over that. And then they decide to sell. It can actually be a year or more for that property from the time that we sue until the time that we actually get to foreclose on it. So be aware that there's a little bit of a maze here, and it takes a long time for this process to complete. Okay, I want to share this with you briefly. This is just a typical foreclosure order. I wanted you to just see this language. I'm going to spend about a minute on this, but this language grants you both a monetary judgment that you can then collect on using those more traditional methods, things like garnishment, levy of assets, that sort of thing. But it also grants us the ability here, as you can see, to foreclose upon that property. One of the nice things as well is in this process that we can, as an association, credit bid, meaning we don't have to bring any money to the sale with us. We get a credit bid up to the amount of our judgment. And so what that means basically is that it makes it a lot easier for us to go and kind of start the foreclosure process with the sheriff and with the bidders. I'll explain more about this in just a little bit, but this is the typical foreclosure order that we're going to be utilizing in these cases. Okay. So what's it like on auction day? It's crowded. This is an actual picture of Fulton County during a foreclosure day. In Georgia, foreclosures can happen only one day per month. Okay, that's the first Tuesday of the month, unless that's a legal holiday. And then it gets moved to Wednesday. There are a ton of people down there, a ton of investors. They are looking for deals, and they will bid on properties. I can't remember the last time that our firm initiated a foreclosure action where a property did not actually get bid on and bid on by and sold to a third party. So in really no case right now is there going to be a situation where the HOA is going to end up owning that property. And that's not the goal either. The goal is not for you to own the property. The goal of this is to expose this property for sale so that through the sale process, your HOA will get paid in full on the judgment amount and possibly even more. If there's a post-judgment amount, we can also try to claim that in that overall process. These are cash sales. So everybody who comes and bids on these properties has to have the money then and there. As far as results, I often get asked this question: how does it work? What can we expect? And the longer I'm in this business, y'all, I can tell you basically to just expect the unexpected, okay? As I mentioned, the goal is not for the HOA to own the property. So as George Bush said, we need some strategery to think through the process and what we're going to be doing. We're going to be attending the sale on behalf of the HOA and starting the bidding process. And then we're going to kind of give it up and let the competitive bidders bid amongst themselves, right? And bid that property price up at least above the amount of our judgment. And so that's why we kind of have to watch the process initially, think about it, possibly enter another bid if it seems like the bidding is slowing down and we want to, gin up the interest a little bit more. I mentioned before, what's the mortgage company doing? We always need to pay attention to that. There can always be a last minute bankruptcy or a temporary restraining order. Sometimes people can refinance their mortgage loans at the last minute. And at that point, you may get paid through that process as well, and we don't have to sell. So we may have to cancel the sale the day before or even the morning of. We are checking bankruptcy and other records the morning of sale because the sale starts at 10 o'clock in the morning. So we're checking those in the morning to make sure there's no last minute filings. 90+% of these cases, y'all, they work out. They really actually don't get foreclosed on through an adverse sale process. And people find money to pay you in also unexpected places. And I'll give you a few examples of this. One, the homeowner owed us $20,000. And once he got the notice of sale from the sheriff, he was in my office within a day or two with a $10,000 certified check with a promise to pay the remainder within the next few days. And I'll never forget his quote. He said to me, "Mr. Olson, I never knew that my HOA could do that." But yes, we had the power to do it. And I was very happy that, he made good with the HOA and got back in good standing. Another one, I call this the sugar daddy case. We had a judgment against a lady and we're about to foreclose on her. And I got a random check in the mail from someone named Harold who lived in North Carolina. He didn't live at the property address, or at least that's not what his check said. I had no idea who Harold was. I'd never heard of him, never spoken to him. Our homeowner's name was Anna. So my conclusion was he's some kind of sugar daddy. And frankly, I didn't really ask anymore, and I, don't care to. Harold's money is also green, and my HOA got paid back everything it was owed. And that's really what counts. And then lastly, this was the strangest case that I ever had, where an owner actually came to his own foreclosure sale. He only owed us $15,000, and that's after judgment, right? So that's after my fees and everything. So he owed less than that even before we filed suit, but he refused to work anything out with us. We got a judgment against him. We sent it to the sheriff. The sheriff starts the foreclosure. The guy comes to his own sale and he bids competitively on his own property and wins. And he actually had the money. This wasn't some kind of fakery that he did, with the sheriff to, try to just gum up the sale works. He actually had the money. He actually bought his own property back. It was frankly craziest thing I've ever seen. So, and I've been around a minute. So in any event, those are some more stories that I have from foreclosures. So this is my last slide on this. And I know I've talked kind of fast in the last couple minutes because I'm trying to hurry up and leave some time for questions. So as far as foreclosures, the courtroom and the legislative climate, first and foremost, we're having problems with some sheriffs in the outlying counties in Georgia, not necessarily the metro counties, but what they're doing is they are either putting our foreclosure files away in some desk drawer and not acting on them, or alternatively, they're calling up the homeowners and trying to work out payment plans without any input from my HOAs. There's been two instances where I've actually had to write some maybe not so nice letters to the county attorneys in these counties and tell them, you're not following process. Your sheriffs are required to execute these judgments and take them to sale, and you're not doing that, and you have to do it. Fortunately, some of those problems are resolving themselves, but it still exists. But you can see the sheriffs are kind of acting as a backstop, right, against what we're trying to do. We've also seen some judges maybe forget to put foreclosure language in the orders that we send them. We'll send them a draft order, and whatever we get back signed, sometimes mysteriously is missing that language. And that actually happened in the Deer Lake case that we looked at earlier. And that's one of the things they won on, the association did on appeal, was that the association was entitled to that foreclosure relief, and the judge just didn't put it in the final order. And then lastly, this legislative effort and the climate in the legislature, I think, again, there were 6 or 7 bills that came down and were introduced into our legislature, and they did everything from proposing that there be an ombudsman or an overseer over every HOA dispute in Georgia with a homeowner. That would have required every homeowner in Georgia to pay a $25 fee to fund that office. It would have curtailed an HOA's right to foreclose based upon a fining balance. Some of these bills would have made mediation mandatory for an HOA at their sole expense, free to the homeowner, but at our expense, okay, before we could sue them. It would require HOAs to waive assessments in the event of death or disability, even though you have a lien against the property in addition to the personal liability of the owner. And one bill would even require the Georgia Secretary of State to grant an HOA permission before it could foreclose. So I'll leave you with this. You've got some folks out there that are angry. They're well organized. They're down at our legislature. They are testifying. They have the ear of some of our legislators. And so I want to encourage everyone here tonight in kind of a closing thought. If you support this industry, I want you to contact your state representatives when this comes around again, because it will. These bills are not going away. They will be reintroduced. And we need to be out there telling our side of the story, telling these legislatures that these bills that you're proposing are going to decimate our industry. It's going to decimate the ability of an HOA to enact fines, to enact foreclosure remedies, all the things that we all agreed to, right? When we moved into an HOA and agreed to this particular scheme of private rulemaking, which is what an HOA is. It's a private rulemaking body, and we have the right to determine for ourselves, without state interference and governmental interference, how we're going to run our HOA. So I encourage you to do that when the legislature comes back into session later this year or next year. Okay. So that's going to conclude my remarks. I appreciate you listening very much. Melissa, I'll turn it back to you if we have some time for questions.
We sure do. And
Okay.
Thanks, everybody. I know we're right at the 60-minute mark, but as we kind of told Frank when we were doing our pre-meeting discussion, we'd rather you get all the content in and have some of you stay if you can. We'd love to hear from you as we kind of go through the Q&A section. We've got a lot of questions to get through. And I really like the thought process that a lot of you in the audience are having as you're listening to some of the topics that Frank has kind of just discussed. I just want to, before we get into the questions, I really want to piggyback off of what Frank just said, his last closing statement. As many of you know, we are proud sponsors of Community Associations Institute for our Georgia chapter, as well as obviously the national chapter for that organization. And lots of us have LAC committees or legislative action committees that advocate state specific for a lot of the legislation that's coming through. And I'm so glad that you actually brought up that last part of the most recent legislation because it's incredibly scary, not just for your industry,
Right.
but for the management professionals as well. Because, your boards also reach out to us if they are professionally managed and say, hey, at what point do we need to get our attorney involved in some of these things? But I think that you gave such a great roadmap. For your recommendations on how to kind of go through these processes. And um, people are going to be pointing out the 2-year statute of limitations. So I'm so glad that you kind of touched on that. We've got some savvy board members that are in the audience that are starting to pick up on how that's possibly going to come into play with some of these things. So I know we left off on foreclosures, so we're going to hop back up to the enforcement procedures and talk about the fining and so forth. And so I think to kind of get this started, if you wouldn't mind, could you just quickly define self-help again for the audience? Because we did get a
Sure.
question about what is self-help. It sounds like this person is probably a new volunteer
Yep.
and may not really understand what the benefit of this operation
Mhm.
is.
Sure. So self-help really refers to a right, if it's granted in
Mm.
a declaration, that enables an HOA to enter upon someone's lot and cure or abate a violation. We see this most commonly in architectural issues. If, say, someone, not to go back to my shed example, but if someone's building a shed and it's not approved, the HOA has an ability to enter upon that person's lot and dismantle the shed. If, again, if it's in the covenants. But that's what self-help is. And it's obviously problematic, as I mentioned before, because what you're doing, even though you may have the covenantal right to do it, that's all great, ivory tower stuff. Let's get down to brass tacks. You're talking about walking onto somebody's land and starting to do work on their house or their lawn or something like that without their consent. I can think of few instances where a homeowner is going to be very happy about that. I know personally I wouldn't be. Um, and in many cases, that may be met with some force. And I think you're also going to have a practical issue with enacting that remedy, even at the vendor level. I don't know that you're going to have the ability without, say, a court order that allows you onto that property to go on that property with a vendor. In some cases, I've even had HOAs ask me to initiate actions and have an order crafted to that regard that allows the HOA to enter the property and also directs a deputy sheriff to accompany a board member and or the vendor or agent onto that property. So that's kind of a long-winded answer, Melissa, to what self-help is. But I wanted to make sure I touched on the practical aspects of it because, yes, I see it very frequently in covenants stated, and it's all well and good. It's also very theoretical.
I was going to say, so first off, I think that that's a great answer, and I'm glad that you gave it as much description as you did. There are definitely certain circumstances where self-help is incredibly beneficial.
Mhm.
You might not have a threatening neighbor, and you might be able to go ahead and remedy something, but to Frank's perspective, the civility of our ownership and our neighbors that we love so much is getting really contentious. And so I think the idea of self-help, and I'm just saying my opinion, the idea of self-help was really good about 10 years ago. It's really that topography has changed a lot. And so, while it does work for a lot of you, and you really should consider it if you have that capability, I think Frank is being incredibly honest with the current temperature of 2025. Where do we see? What are the success stories? And what are the real challenges? And I think a lot more of our boards are finding that it's really difficult, even with that self help abatement provision that you might have within your declaration to still even actually be able to carry it out. Hence why he said he's even had to write, something for a board member to be able to have a deputy sheriff join them on a property. So kind of going back to the Deer Lake case and tying in that mailbox example a little bit. This is really, this was actually a great question. It's more specific for condominiums or possibly even townhomes. We're talking about entry for life safety reasons. So let's say it's sprinkler inspections, or there's some other life safety that needs to happen on an annual basis. And we've got a homeowner that just is not allowing us entry into their unit.
Right.
Is self-help a consideration potentially in this situation?
I would say, again, theoretically, yes. Practically, you need to gauge
Yeah.
that homeowner and how are they going to react to someone trying to enter their home by force. And if you're talking about a condo or a townhome unit and entering the interior, right, then you're talking about taking a locksmith with you, because that more than likely that property is going to be locked. And more likely than not, even though there may be a requirement in the covenant for that homeowner to give a key to the association for that entry purpose, they never do, right? So what you're left with is taking a locksmith and telling that locksmith, hey, bust that lock on this unit. And they're going to look at you sideways and say, I'm not going to do that. I'm not going to endanger my life and endanger my, livelihood and get sued at a minimum by doing something like that. So we've had some real trouble enacting that type of remedy. And that's why I know I'm kind of saying the same thing over and over again. So the solution to this, guys, as I see it, if you've got that right to enter in for safety and health reasons, and you can't get the owner to cooperate, you're going to have to get a court order. Maybe we get a immediate, you can go into court and really kind of get an immediate order that would last, say, for example, 30 days. It's like a temporary order that would give you that temporary right to enter upon that property. And again, I want the sheriff involved. I want somebody, frankly, with a vest and a weapon to do that. I don't want my boards and even their vendors, going it alone. They need the force of a judge's signature, forcing that owner to comply, and a lawman with them, if you will.
And friends, doesn't this fly in the face of building community? Like, can we just say that out loud real fast? Like, one of the biggest parts as a board member, even as a homeowner that may not be quite volunteering just yet. I mean, the sense of responsibility and the duty of care and loyalty that a board member has to their ownership, right? To have to sit and contemplate all of these really big items. And then we have legislation on the back end that is very homeowner focused, which makes total sense. There's oftentimes a little bit of a disconnect. And because Frank pointed this out very, very well, each individual association is its own entity. It makes its own decisions. It has that capability to do that. Obviously, certain measures need to be followed, and we don't want there to be selective enforcement and all of those fun things. But this is kind of, bringing all of this topic full circle. It can be very frustrating. And I know that we're all kind of seeing that. We are seeing that in volunteerism efforts being heavily strained because of topics like this. So, okay, I'm going to
Melissa,
kind of go ahead. I'm sorry.
Can I give you one more thought on this?
Yeah.
So this is somewhat related. So we had a situation in a condominium. It's a little bit older condominium. What the insurance company was requiring my client to do was upgrade its wiring, and wiring not only in common areas, but also in the interior of units. It was aluminum wiring, I think, from the 70s, which is fire prone. And so I think there's like caps or something. I'm probably explaining this all wrong, but I think there's caps that you can put on the ends of wires to alleviate the fire risk. We had, in a community of 47 units, one unit that simply wouldn't do it, right? Everybody else complied. Everybody else invited our vendor in to do it. Our solution in that particular instance was we said, all right, if you won't let our person in, then you go get your own electrician and get them to sign this certification that the work's been done as an alternative, to that's like door number 3 versus them letting you in and you forcing your way in. You do the work, you certified us that it's been done. They could do that in the sprinkler case as well. Certify to us that you've had your sprinkler inspected and that it passes code or whatever the HOA needs, right? And have a written certification from the person who did it. Maybe that's a solution.
Yeah, we see that from time to time, if we've got to turn water off to a building, and one particular owner's not allowing access, there's so many different ways that can be. So I appreciate the person that asked that question because, it's a very heavy one. And oftentimes the answers, just like with all of this, are going to be, so I'm going to try and consolidate some of the questions that we've got so that I can kind of paint this really nice picture so that we can kind of go through some of these a little bit faster, just because we have so many, Frank. And I mean that in the nicest way possible. Thank you to everybody that is wanting to participate in this because this is a great topic. That's why we're hosting this class. This is probably the number one topic nationally being spoken in every state, not just the state of Georgia, because there's the legislation is changing the topography nationally, not just statewide. Okay, so we're going to talk. I'm going to kind of pull out something that somebody did not say, but I'm going to say it to you, and I know you're going to know what I mean, and we can talk about this. But we're talking about the difference between a static and a continuous violation, right? And you had talked about creating a board resolution. If you've got enforcement procedures or if you've got fining procedures, going ahead and making that really nice resolution. And just putting it out on paper. And so we just kind of got a question from an audience member that was really kind of asking, like, hey, what do we do in these circumstances where it's something trivial, like they've got a sign in their front yard versus somebody just chopped down a tree that didn't get modification approval? And what do I do in that particular situation? And really, I think what this question is lending to is, are there differences in fines? Should we articulate different scenarios in our fine policy? And that's where I came in and said, "Ooh, let me plug in words if you didn't know the difference between a static and a continuing violation."
Right. So really, a continuing violation is something that, as I understand the law, requires separate and distinct acts each time. So every act of someone, say, parking in a spot that they're not supposed to, like, many of my communities, for example, have driveway parking restrictions. They say you have to park in your garage first, and only when your garage is full can you park in the driveway. So each act of them parking on their driveway would be a separate and distinct act. And that's really what the law is looking at as far as a continuous violation. The static violation is something like what you mentioned, which is the sign in the yard, the tree. And so the real question comes down, can you fine and just let the fines accrue and accrue and accrue? Or do you fine a single time for that single act of putting that sign down or chopping down that tree? I would tend to recommend that a static event like that incur a one-time fine. And so to that end, I would be recommending an association enact, a per incident fine based upon, really the severity of it. Like I mentioned earlier, if you are, a tree, to me, chopping down a tree, that seems to me, at least just in my own personal sense of it, carries a lot more heft and a lot more severity to it than someone putting up a little garden sign, it says welcome or something like that. Taking down a tree is a big deal. It's going to leave a mess. It's going to, impede traffic. There's all kinds of things. So I think the board would be well within its rights, hopefully until the court says no, but well within its rights to make that event carry with it a more severe fine than a simple sign in the yard. I'm not in favor. I will say this. I'm not in favor of continuing fines based upon a single event, at least not without a fining cap. I mentioned that earlier. So, again, somebody puts a sign in their yard, maybe you fine them for 15 or 30 days for that, and then you cap it. Because again, I'm trying to take y'all 50,000 feet up on this, which is your fining process has to be fair and it has to be reasonable. Is it fair and reasonable to fine somebody thousands of dollars for a simple sign in their yard? Yes, it violates the covenants. We can all agree on that. But the real question is, I've got to get you a win in the courtroom, right? You know, a win out in, just the ether is that means nothing. If you want to fine somebody and actually have it mean something, you actually have to convert that fine into a judgment and collect on it. Otherwise, the fine will just accrue and nobody will ever pay it, and you'll be left without enforcement. So that's why I guess in situations like that, I would create a graduated fine schedule that gives severity to other things versus, tree is worse than sign. And then I would say, let's cap, these continuing fines. That's again really where the judges are landing as well. They're questioning that. They just see pages after pages of these ledgers that I have to introduce into court with these $25, $25, $25, $25. So at some point they're looking for you to cap them, and that's where I'd land on that question.
And I'll even kind of slightly answer this one too. There was another question that I think is a little bit of a caveat to the resolution as well. Are we allowed to give friendly warning notices before we have to evoke what the declaration outlines? Typically, your declaration is going to outline what your notice provision is. And oftentimes, we definitely see, especially as the managing agent, that, if we partner with you, we also are the ones that are sending out those notices from time to time on behalf of your board of directors, either with, their direction or by us doing the inspection with our own eyes. A lot of boards ask us to do a courtesy notice in addition to what is already outlined within their governing documents. It just becomes to the point which you have this is where you have that flexibility and that capability to do it. It just comes to a point where you need to be consistent with all things that you do. And there has to be the disclosure to the community of what's going to be the penalty if that does happen. So if you used to give 3 letters and now you want to give 4, you just need to update that policy and send it back out to the neighborhood before you start moving forward with what some of those remedies are going to look like. So I do like some of those questions. Some of these are starting to get really technical, which we love. And these are very thought-provoking questions that maybe most of you need to come back to your association's attorney and say, hey, listen, let's just do a quick review of what we're doing, or maybe get with your property manager if you are privileged to partner with a property manager. Make sure that these procedures are outlined. Most fining procedures also have to, if not already, have gone through your attorney. So no worries there. It's just when you want to go ahead and alter. I'm going to shift gears real fast and go into leasing. We got a couple of questions about leasing.
Oh, okay.
And that is a huge contentious. I'll tell you this, leasing is among the most litigious topic that we have, that we see in, our management company and what we work with our community, board members and homeowners with. And so we've gotten kind of, again, I'm going to bundle some of these questions for you. So, this is specifically related to the illegal leasing. Maybe not understanding how are we supposed to identify when somebody's leasing potentially, and what do we do in the event that we don't even know when the statute of limitation for that 2 years notice provision, like, hey, if I didn't know this person was leasing, am I a board member now in trouble because I didn't do something that I was supposed to do? So I know that was a lot of information, but those are a lot of questions that I thought would probably just be nicely bundled right here.
Okay, I'll start with the easiest question first, which is, and I don't know that this is necessarily an easy answer, but if you're trying to figure out whether a home is leased or not.
Mm.
Tax records are always public. And one big tell is going to be if that home is owned by American Homes for Rent LLC or Invitation Homes or Progress Residential
Right.
or SFR Borrower One
Mm-hmm.
LLC, these
Mm-hmm.
names that keep coming up, you see corporations. That's a big tell that that home is going to be leased. The other big tell is whether or not a homestead exemption is taken out on that particular piece of property.
Mhm.
So a homestead exemption gives you, for anybody who doesn't know, it gives you a break on your property taxes for the home that you live in as your primary residence. A rental property, by definition, cannot be a primary residence for the owner because the owner has relinquished their possession rights to their tenant. Therefore, they are prohibited by law from claiming a homestead exemption on that piece of property. So that's a huge tell for me. And that's usually the first place that I look
Mhm.
is those tax rolls.
The tax assessor's website, friends. For those of
Yes.
you, that's what you just Google your county's tax assessor website, and just like he's saying, you can search by the name or the property address. That's a
Mhm.
lot of what it is that we do too. Frank had also mentioned there are a lot of really great leasing programs out there too. Again, whether you're partnered with a professional management company or not, there are third-party companies, and most management companies have separate programs that can help you with monitoring leasing. So if you are unaware of what you can do, you have, if leasing is just flat out not allowed in your organization at all, and you think that there is suspect to that, there are definitely things that you can do. Again, consult your legal counsel, get with your property management company, or start taking a look at some third-party leasing opportunity. Organizations that can help you with that monitoring. So just know that those things do exist. They do cost money, but they do exist, and they're there to help provide peace of mind to the board of directors, especially for these insurance circumstances. That Frank had also mentioned that oftentimes FHA is not included. It's an exclusion in your D&O policy for your insurance. So, and for those of you who had joined us earlier this year, we did a two-parter class on fair housing. So we've got you covered on that if you're joining us for the first time and you want to hear some more about fair housing and how that can be applicable. We've got some other great course content for you. Okay, so in addition to kind of this right here, um, this is a fantastic question. We see bankruptcy bouncers, Frank. The people
Yes.
that go into bankruptcy to avoid foreclosure.
Yes.
This question came through.
Hmm.
Can a delinquent homeowner use moving their property into a trust as a way of avoiding foreclosure? Do you see that at all?
Couple things on that. Number one, if there is a debt owed on a property, and especially if you're a POA or a condo, this is a huge reason to become a POA if you have any ability to do it. The
Mm-hmm.
POA strengthens, as does the Condo Act, the ability of the association to have joint and several liability against seller and buyer. So if somebody transfers their property into a trust and doesn't pay the association in that transfer everything it's owed, that homeowner is still going to owe that debt. And now they've made the trust that they created liable for the debt as well. Even though, I don't want to get too technical on trust, but um, basically that's, in my view, not a good way for that homeowner to escape or avoid liability at all.
Sure.
Um, so just by virtue of the transfer, and I see, it's not just trusts. I see quit claim deeds all the time
Mm-hmm.
in our practice where people are trying to do that, often on the eve of foreclosure or on the eve of judgment. And, what I tell people is, look, you've just made somebody else liable with you for the debt because you didn't pay us. And you're supposed to pay us. You're supposed to pay us at that closing or that transfer. That's what there's a whole process called an estoppel letter that's
Yep.
supposed to be issued by the association. listing the amounts due. You're supposed to request that from your association or its property manager. And that's what tells you what to pay at your closing. If you don't do that, both people are going to be liable at the end of the day.
Yeah, and obviously our common law HOA friends, life is a little bit different for you.
Mhm.
This is where you have oftentimes your declaration in the Georgia Nonprofit Corporation Code that kicks in and kind of does some of these things, which is why Frank is so wonderfully talking about that. If you're considering any amendment and you're not a POA or a condo, meaning you're a common law HOA, the only amendment you should really consider is amending to the POA, because that will bring a lot of these things into an alignment for your declaration. And again, talk to your property manager, your management company, your attorney offline about some of those resources, because that's really going to be so helpful for you in some of these remedies that we're talking about tonight. And again, in the spirit of being neighborly and doing the right things, sometimes what we have to do is really unsavory, and we know that that's really difficult. But at the end of the day, the association is owed money. The association is responsible when we're talking about
Mhm.
foreclosures of certain things, right? Non-paying assessments, those types of things. That money is owed the association, so you can continue to do the things that you're required to do, whether that's maintenance or upkeep or enhancement, all of those things. And just as Frank said, you chose to live in this property, i.e., you purchased this property that has restrictive covenants, that you're required to follow these rules. So, all right. So, this is an unsavory topic, but it's, I think, a valid question. What
Mhm.
happens to a board? Like, does a board become negligent if
Mm.
they don't enforce collections on for recovering fees in a situation like this? Or does a board potentially become negligent if they don't force foreclosure, or at least send a foreclosure notice of capability? We're not saying that every single
Yeah.
time this is what needs to happen, of course, friends.
Mhm.
But is there a point in time where a board can become negligent if they don't assume the legal responsibility and remedies that are made available to them?
I think that argument could be made if the HOA's failure to enforce and send things to collections, especially if, for example, in Georgia, we talked about the 2-year statute. There's a 4-year statute to collect assessments.
Hmm.
So if you are waiting 10 years before you decide you want to sue somebody, you have done your HOA a disservice by not initiating a collection action on that balance. So you've lost 6 years of assessments. You can only go after the last 4, not the last 10. So that would be an issue that I would see. The bigger issue would simply, be as well one of uniformity. Whatever
Hmm.
policy you decide on as far as collections, it needs to be uniform as to everybody. You need to enforce it against everybody. Be consistent to the T. Do not deviate from it. Do not treat people differently. That's the hallmark. You start treating people differently, whether, maybe they're just your friends and you want to be nicer to somebody. You can't start granting exceptions to some people and be hard on other people. That's not going to work. That's where a negligence claim probably also would come in. But yes, I would say that boards have a fiduciary duty to the association that they are empowered to represent, to promptly and seasonably attempt collections when they can. And some of this is, it will be a balancing act, right? If somebody owes you $100, it doesn't make sense to hire me, honestly, to spend what 2,000 roughly of your money, which is what a lawsuit generally takes. It costs around
Right.
$2,000 for soup to nuts for me to go get a judgment against that person. Even if I have the ability in the covenant to go collect that amount, it makes more sense to, reach a better tipping point. Like, and judges like this too, I will say this, that if the amount of assessments and other fees that you're seeking to collect is going to be equal to or more than the amount of attorney's fees that you have to spend to get there, that's a good um, that's a good balance, and that's a place where a judge can hang his or her hat on, and that's going to be palatable to them. That's why a collections policy, by the way, is very important to have, because it eliminates all that uncertainty. If you have a collections policy that says, whether it's based on month, of delinquency, or based on amount. And again, some of this POA and condo is going to be maybe dictated as well by the statutory minimum. But if you have a collections policy in place that says, okay, after X amount of time, X amount of dollars, whatever, we're going to initiate a foreclosure action or a monetary judgment action, then all you have to do is follow the policy. It's a set it and forget it. You're not going to be held liable in negligence because you followed the policy and you set one to begin with. That in itself, to me, setting a policy like that is an act of fulfillment of a fiduciary duty.
Mhm.
Again, long answer, sorry.
No, it's great. And there's lots of little caveats. I can hear a lot of counters to some of the things like, hey, well, that's how the old board did it, and we're the new board, and we want to do it this way now. And
Mhm.
and it's not to say that those thought processes aren't fair, aren't valid
Mhm.
in particular circumstances. You should be reassessing and reviewing a lot of your policies. But the last thing you should be doing is not taking any action of any sort, because it does cost the homeowners that do pay good money into the association. It actually penalizes those that pay their assessments on time in some of these circumstances as well. And sometimes this is where we can see, associations, the amounts get so long, they get so large, who has the ability to pay that? I can't pay
Mhm.
$50,000 for back due certain things. So, I mean, there are legitimate arguments. That's why this is not as easy in each circumstance. And don't forget, these are executive item topics. These are not topics to be willy-nilly shared with the general public. When you've got, fines for enforcement, when you've got foreclosures or delinquency notices, these are all things that are talked about in executive session. These are things that are board
Mhm.
access only. This is not open ownership type topics. Yes, can the ownership see that you have $20,000 uncollectible because you budgeted 100,000 and only brought in 80? Of course, they can see that on the budget. Those are types of things that are common that people can see, okay, hey, we've got some delinquency going on. But as far as specific information about the interactions of what's happening within an organization, that's going to be kept very high level, very protected information. And the board has the right to review each one of those things individually. But as Frank is talking about, having these policies in place so that you can have the consistency, not necessarily always uniformity, but the consistency
Mhm.
of application of how certain things are going to be followed in certain circumstances, that can be so beneficial for board members. So we have asked you all to stay for about 30 extra minutes, and there have been so many questions. I know we didn't get a chance to get to all of them, but the main topics of what the questions we started to receive, I think you've done a great job in answering and isolating. A lot of you who have some very detailed questions, again, I encourage you to get with your association's attorney, maybe talk about some of these things. If you heard something that percolates a thought that maybe you and your board members need to revisit certain things, or you just want to double check that your I's are dotted and your T's are crossed for your organization, there's nothing wrong with that. We certainly encourage you to do that. We thank everybody for giving us so much of your time this evening. We are so grateful for our partnership that we have with Cobb Olson and Anderley, and the fact that Frank too, that you decided to give up so much time. I know this is such a heavy topic or topics, but you can tell that they are so important, and we sincerely appreciate all of your expertise that you bring and your knowledge that you're sharing with us in this opportunity. So for everybody, we are going to be sending out shortly a feedback information survey, or I should say email tomorrow, as we normally do, asking you guys, about your experience with us. We are going to be providing you copies of this presentation and the link for you to be able to watch this on replay. So hopefully you'll be able to learn a couple more things as you go back and watch this, and feel free to share this with anybody else that you think would find value. We sincerely thank you from Heritage University and from Heritage Property Management. We sincerely thank all of you for joining us.